That's the whole theory upon which it is. That's absurd. So we showed that, and we showed that the minister, when the minister issued the authority to proceed, was not in any way affected by any bias. They are not alleging that the minister did not perform her statutory functions. The minister has some functions to perform. There is no allegation that she didn't perform them or that she performed them in violation of the Act or that she violated her responsibilities under the Act. Nothing like that. The extradition process is a statutory process. The minister complied with that, bias or no bias. Bias doesn't have a role to play. I had to give the minister certain legal advice. The law doesn't change because I may be biased or because whatever apprehension I'm under politically. I have to advise based upon the law. There is no evidence that they could have produced to show that, we would have acted differently had it been someone else. And they're saying that you should have delegated the responsibility. Treaty obligations.
We are diving into a case today that really just perfectly captures this tension between international law, executive power, and, raw political combat.
Mm-hmm.
This isn't just a legal battle. It's a fight over whether the pressure cooker of political rivalry can fundamentally invalidate a government decision.
Exactly. We're tracking the sources on the judicial review of the extradition proceedings for two very prominent businessmen, Osred Mohamed and his father, Nazar Mohammed.
And the allegations are serious.
Oh, incredibly serious. They're U.S. indicted for money laundering, fraud, with reported ties to major international organized crime. We're talking the Russian mafia, Hezbollah. The stakes are just enormous.
For Guyana, for its international relationships, everything.
Everything.
So the central question before the court, it's really profound. The Mohammeds are challenging their extradition by arguing that the initial decision to proceed, what's called the authority to proceed.
The ATP, yeah, the authority to proceed.
Right. They're saying that the ATP, which was issued by the Minister of Home Affairs, Onij Walrond, was entirely ruined, tainted by political bias.
And that's the core mission of this deep dive. So we are unpacking that legal clash, which is right now before Acting Chief Justice Navendra Singh. Does all this intense political heat mean the minister just couldn't have had the necessary impartiality to sign that document?
Right.
We have to get into the nuts and bolts of the Fugitive Offenders Act, which governs this whole thing, and, weigh the claims of political malice against the state's argument that this was just a mechanical required step.
And you pointed out earlier, we should remember this isn't happening in a vacuum. There's a separate, broader challenge going on at the same time.
Mm-hmm. They're also contesting the constitutionality of recent amendments to that very same act.
So they're attacking the process from every possible angle.
Maximizing their options. Absolutely.
Okay, so let's unpack that first salvo from the Mohammed side. Their attorney, Sion Durjan, he built this argument on the idea of, twofold political bias.
Yes, twofold. Claiming both the Minister of Home Affairs and the Attorney General's office were compromised.
So how did they try to prove that bias? How did it manifest?
Well, the defense's main legal tool here was to build a narrative of inescapable political prejudice.
Okay.
They argued that because the minister is so closely associated with the ruling PPPC, which, and this is a key detail, Durjan strategically characterized in court as a pressure group.
A pressure group, not a political party.
A pressure group. The language is very deliberate. The idea is that she couldn't possibly have acted impartially, even if she wanted to. And this is where the timeline becomes so critical.
Let's talk about that timeline. It really sets the stage.
The defense meticulously documented, I think it was 15 public statements made by the ruling party's heavy hitters.
The president, the VP.
The president, the vice president, the AG, all of them. And this is all between June and August of 2025. And these weren't neutral statements.
Yeah.
The defense argued they explicitly portrayed the Mohammeds as criminals who were already guilty of these extraditable offenses.
So you've got the entire executive leadership publicly labeling these guys as guilty, and then just a couple of months later, in October, the minister, who is part of that same leadership, signs the legal document that kicks the whole thing off.
Exactly.
I mean, it's hard to argue those two things are completely disconnected.
And that is the defense's precise point. They're saying this political atmosphere basically turned the minister into a prosecutor instead of a neutral official just doing a statutory duty.
I see.
They claim the damage was done long before she picked up the pen. Her action in October was, in their view, a foregone conclusion, not some kind of balanced administrative decision.
And it wasn't just the political rhetoric, was it? They raised a specific legal point about where the crimes happened, the territoriality.
Yes. The claim that about 90% of the alleged criminal conduct happened in Guyana, not in the U.S.
Why is that geographic split so important in a case like this?
It's a crucial substantive legal angle that often gets lost in all the political noise. Most extradition treaties and the Fugitive Offenders Act itself, they have provisions linked to territoriality.
Right.
The defense is trying to argue that if the overwhelming majority, 90% of the criminal activity was domestic, then Guyana has the primary right, and maybe even the obligation, to prosecute those crimes itself.
So the U.S. request is valid, but Guyana should be the one to handle it. It's their jurisdiction.
Exactly. It's a jurisdictional dispute. It's basically saying, why are we handing this case over when most of the evidence, the witnesses, the impact, it's all right here?
And that ties back to the bias claim.
It does, because the defense suggests the minister was biased towards just fulfilling a foreign request instead of, protecting Guyana's own legal sovereignty.
And of course, we can't forget the political elephant in the room that the defense brought right into the courtroom.
The fact that Azruddin Mohammed is a major figure in the Win Party.
Yeah, with 16 seats, he's seen as the presumptive opposition leader. This really adds a whole other layer of motivation to the alleged bias.
Absolutely. The defense presented this as a classic case of political maneuvering. The ruling party using the power of the state to get rid of a major political rival by sending him overseas.
And to make that bias argument really stick, they didn't just talk about conscious intent, did they? They brought up this concept of unconscious bias.
That concept is fascinating here. It means the minister doesn't have to be maliciously plotting to remove a rival.
Right.
The political environment itself, the sheer volume of those 15 statements, is enough to taint the decision. They argued that because of all that noise, the legal burden was on the minister to prove, actively demonstrate, that she had put those prejudicial statements out of her mind when she signed the ATP.
That's an incredibly high bar for any politician to clear.
It's a judicial standard, really. For a judge, impartiality is the job. For a minister, partisan politics is also the job. The defense is trying to apply the judicial standard to the executive.
That is the tension right there. So that's the defense. Tainted by politics, compromised by jurisdiction. Now let's pivot. The state's defense, led by senior counsel Douglas Mendez and AG Anil Nandlal. They didn't just say there was no bias. They said the whole question of bias was, what, irrelevant?
That's the key distinction. Mendez's submission was surgical. He argued that the rule against bias, the whole idea the defense is leaning on, it just does not apply to the minister's decision to issue an ATP.
How can it not apply? It seems so fundamental.
Because, he argued, that function is not judicial. It's not even quasi-judicial. It's a fundamentally executive, administrative, and political function.
Oh, wait, isn't it a bit naive to think any minister, especially in a country with such high-stakes politics, could be totally free of political baggage? Where does the law draw that practical line?
Mendez drew the line at the nature of the action itself, not the minister's personal feelings. The ATP is simply the document required by law to start the legal process that was requested by a treaty partner, the U.S.
So it's an obligation.
It's a mandatory administrative step. He's basically saying the minister is just rubber stamping an international obligation. She's not judging guilt or innocence.
So her personal opinion of the Mohammeds doesn't matter.
It's irrelevant. She makes no binding decision on the facts of the crime. Mendez really stressed that the ATP is just the first domino. The real due process for the Mohammeds is protected by this long judicial gauntlet.
The magistrate's court, the high court.
Exactly. The committal hearing at the magistrate's court, then reviews at the high court, the court of appeal, and then finally the Caribbean Court of Justice, the CCJ. The minister's role is simply to move the request from the U.S. ambassador's desk to the Guyanese magistrate's desk.
And he also pointed out that the request came from the U.S., not from the PPPC administration itself.
Correct. And that if the minister refused to sign it, or even tried to delegate it, she would be breaking the law and violating Guyana's international treaty obligations.
Which leads right into what A.G. Nandal argued.
It does. Nandal called the whole judicial review legally baseless and an abusive process. He used the phrase satellite litigation.
That is a powerful phrase.
It is. He argued that extradition is a high-level, government-to-government process. It can't be constantly interrupted or, as he said, fragmented by these domestic challenges over the very first administrative step.
He was basically saying they're trying to shut the whole thing down before a judge even gets to see the evidence.
That's exactly it. And his argument about the political safe haven was particularly stark. He wasn't just defending the minister. He was, in a way, defending the principle of law enforcement.
How so?
Well, he challenged this idea that people facing serious international charges could just enter politics after an investigation has started and then use the inevitable political criticism as a shield.
Right. Any action taken against them is then political bias.
Precisely. He said, if politics becomes a safe haven for fugitive offenders, the whole system becomes, and I quote, absurd.
That is a profound point about the precedent this case could set. If the court sides with the defense, it could open the floodgates for anyone prominent to just claim political bias and stall things forever.
It could set up a sort of a constitutional crisis. And Nandla's summation hammered this home. He said whether the minister is subjectively biased or not is immaterial.
Immaterial.
Because issuing the ATP is a mechanical function. It requires no subjective judgment, no impartiality, just follow the statute.
Before we move on, there was a fascinating side note about the legal team for the state. You mentioned the AG revealed something about the lawyers.
Yes, this was very telling. AG Nandl revealed that some of the highly experienced attorneys for the state, including senior counsel Douglas Mendez from Trinidad, are offering their services pro bono.
So for free?
For free. No payment. And this detail, it kind of reframes the state's entire defense. It suggests the government sees this case not just as defending one minister's decision, but as a critical defense of the state's sovereignty and its ability to honor its international treaties. It's a matter of national importance that goes beyond legal fees.
That really speaks volumes. Okay, so let's pull back and look at the backdrop here. This complex legal fight is happening in what the sources describe as a scorched earth political environment.
That's a good way to put it. This section really illustrates the intense political warfare surrounding the case. We have the example of Minister Susan Rodriguez.
Right.
She was forced to issue an open letter responding to some very serious allegations made against her by a critic, GHK Lal, which had been published by Damara Waves.
And she met it head-on with transparency, providing her mortgage details, financial info, trying to prove everything was acquired lawfully.
She did. She called Lal's claims false and malicious. And she really went after the media outlet for giving it a platform without any, basic scrutiny. But this wasn't just a defense.
It was a counteroffensive.
A full-blown counteroffensive. This is where the tactic becomes so clear. She didn't just stop at defending herself. She immediately pivoted and demanded that the media hold Lal to the very same standard.
And the list of counter-allegations she raised against him was extensive.
It was. And it shows just how toxic the atmosphere is. She brought up long-standing public allegations of pedophilia against him that remain unresolved. She questioned his history at the Guyana Gold Board over a dubious gold export license, implying past corruption.
And she didn't just attack his actions, she went after his credibility, his professional credentials.
Exactly. Her letter questioned if he was even a qualified attorney, saying there's no verifiable public record. She challenged his self-identification as a Wall Street analyst, saying there was no employment history to back it up.
And there was the dispute over that gold smuggling dossier, right?
Yes. She highlighted that Lal's claim that the dossier excluded the Mohameds was directly refuted by a former minister, Raphael Trotman. And then, to top it all off, she questioned his finances, alleging he's a part owner of the very media outlet that platformed him, Damaroy's News Talk Radio.
Wow. So this whole sequence is a case study in selective scrutiny.
It's a perfect illustration. It shows the danger of operating in this kind of environment. When the stakes are this high extradition, organized crime, anyone who criticizes the government, even on something unrelated, opens themselves up to a deep, deep dive into their own history.
It's a mechanism to silence or delegitimize critics.
Absolutely.
Okay, so let's bring it all back to the courtroom. The core tension remains. The Mohameds trying to use political motivation to nullify the ATP.
While the state fights to uphold executive efficiency in international law by arguing the ATP is just a non-judgmental mechanical duty.
And that tension is about to come to a head.
It is. Acting Chief Justice Navindra Singh is set to deliver his ruling on this judicial review, the whole question of bias and process, on February 2nd, 2026.
So that February 2nd ruling is going to tell us if the minister's politics and all that public rhetoric are legally material enough to stop an international extradition at the very first step.
And it's crucial for you to remember that the substantive committal hearing, where the magistrate would actually look at the facts of the alleged crimes, that's still on hold until February 5th and 6th, pending this ruling.
So the court has to decide which principle is more important here. Is it ensuring constitutional fairness and eliminating potential bias? Or is it upholding the executive's duty to honor its treaties without these interruptions?
That is the question.
So what does this all mean for you as someone tracking this intersection of law and power? This case is just a profound lesson in the practical limits of the separation of powers in an extradition context.
It forces us to ask, is the risk of setting a precedent for a safe haven for alleged criminals worth the protection of due process against political meddling?
The law only allows this kind of interruption if the ATP itself is found to be unconstitutional. The state argues letting politics disrupt the process just paralyzes the government.
And the defense argues that ignoring the politics makes a total mockery of fairness.
So the ultimate question hanging in the air, I think, is this. Can an executive decision be legally sound, following the statute to the letter, and yet still be deeply and demonstrably politically motivated? And if so, which of those factors should a court prioritize?
That is something profound for you to consider as we all wait for the Chief Justice's ruling on February 2nd. A fascinating conflict of principles.
Thanks for diving deep with us. We'll catch you next time.